Thank you. Oh. Thank you so much, everyone, for being here. And I'm really excited to welcome Nellie Sandoval, who is from Levitt and Quinn, which is a Los Angeles-based pro bono family law firm. And she's going to be giving us a training on family law basics, which will be particularly good for incoming law students and our newer family lawyers. And but also at the end, we're going to talk about the services that they offer. We've had a lot of calls recently for family law services in LA, so we are probably going to be bombarding you with new client referrals. I hope you don't mind. You're gonna be like, oh, free to thrive again. I've already given your website and phone number to another organization that's going to be sending you some clients directly. And then at the end, my hope is, and we'll continue this conversation with your team when we come and train you all, is to really talk about how we can partner together. And we definitely serve overlapping client populations, but there are certainly our unique needs that our client population has that may be different than your client population. We'll kind of focus our training specifically on the legal needs of human trafficking survivors in the family law system and kind of what makes them the same and what makes them different. But just would love to talk a little bit generally as a group about how we can best support one another. So with that, I'll turn it over to Nellie, and please introduce yourself to all of us, and then take it from there.
Yeah, absolutely. So hi, everyone. Happy to be here. My name is Nayeli Sandoval, but I go by Nelly. Make it easy for everyone. I have been a staff attorney and community engagement coordinator with Levitt Quinn for 4 years now. And with that, hold on, let me see if I can pull up my presentation. Here we are. Oh, sorry. What's going on there? Awesome. Can everyone see it?
Yep.
Okay, awesome. Before I get started, out of curiosity, how many of you guys, I know that you deal with a lot of family law issues. They really start to, they intermingle with a lot of your sex trafficking cases, but how much family law are you guys actually doing?
So we have one attorney.
Sorry, I was struggling to unmute.
Yeah. Long pause. Go ahead,
Sorry.
We're doing a lot. The majority of the work is custody and visitation. The occasional guardianship, the occasional dissolution, but a lot of custody and visitation.
And restraining orders. Don't forget.
Oh, sorry.
Just restraining orders.
Restraining order.
Yeah, and restraining
100%.
Yeah.
Okay, makes sense.
And to give you a sense of our team, Nick is full-time family law. Melissa splits her time between family and criminal. Brooke supports all of our legal teams, and Tammy is mostly focused on post-conviction release on the criminal side, but we also like to cross-train everybody in case people take vacations or anything like that.
Okay. So this essentially is just like a family law basics type of training, a little bit of everything. Divorces, paternities, domestic restraining orders, domestic violence restraining orders, and some guardianship and some information on the dependency court. So there are 3 separate systems that do impact children, and those would be family law, guardianship, and dependency court. And obviously there is adoption as well. We actually do some adoptions, but that's very specialized to one attorney. So I'm not going to give you any bad information on adoptions, but we do have an adoptions attorney. And so essentially let's see here, let me try to move this. How family law works is that the state court judges in each county are assigned a family law department, and then obviously they apply the written law to the legislation and are signed by the governor. Now, this is something I know a lot of people when they come in and they say, the other side started this case, I was going to go ahead and start it. Now they're going to be the one who wins. Now in family law, that's just not the person who starts the court case is the petitioner. They don't automatically get what they want. The person being sued, which I know for some people is like a really weird word to understand, like, how am I being sued? But yes, a family law action is like being sued, is the respondent. They both have the constitutional right for notice and opportunity to be heard. They both have default rights, which basically means if the other side does not respond, they can be kicked out of the case. And obviously in family court, you do not have the right to a free attorney. In fact, I think it's like over 80% of people in family law are self-represented. That's why it's so convoluted and it gets so tough. And they try to move people to self-help or the Shriver Project or things like that, at least in LA, because there are so many people who are trying to do it on their own, and it can get tough. So let's see here. The types of cases that we'll see in a family law case include a dissolution of marriage or a divorce, where one spouse is filing to divorce either their spouse or their domestic partner. Then there's a legal separation. That is a spouse who wants to separate under law but doesn't actually want a divorce. And typically these cases are for people who either don't want the title of divorce or reverting back to single for religious reasons. And I've also seen it done for insurance purpose reasons. When you are divorced, there are insurance companies that make you take your spouse off. It's just the agency, it's just law. Whether or not that person wants to continue to have the ex-spouse on there is not a matter of want. It is just the agency and what they require. And so sometimes in order to get around this, if insurance is such a big important part of that marriage or partnership, then they do go ahead and legally separate. So everything is separated, property, all of that, except they're not actually reverted back to single, so they can continue to be on the other person's insurance. And then we have nullities, and that is when somebody wants to get a legal determination that the marriage is void or basically never happened. In the state of California, there is a difference between a marriage that is void and a marriage that is voidable. Bigamy is one of those things where it's just void. You can't have, more than one. You can't be married to more than one person. But we see a lot of the issues with fraud. People say they married me for immigration purposes, and I want a nullity. I want to pretend that this never existed. That's all well and fine, but you actually do have to go through a determination and prove that it was fraud. It's actually a really, really tough thing to prove. The court has a pretty low bar for what is considered to be like a pretty good faith marriage. If you had never had intimate relations or did any of that, you probably have a pretty good chance of proving that it was fraud. But even with one time of having an intimate relationship and being married, like they're like, okay, well, you technically consummated the marriage, so something was real there. And then another type of case in family law is a paternity case or a parentage action. And this is typically two parents fighting custody and visitation of the children and support, but they are not married. And then, yes, children can go ahead and file through a guardian ad litem. Oops. And then, so the typical issues which we see in family law include custody and visitation, child support, property division, spousal support, protection from abuse, those are the domestic violence restraining orders, and establishing parentage. Now, the way that a family law case works, and this doesn't matter whether it's a divorce or a parentage action, the petitioner files the petition, which I like to describe to people as their wish list. It's really setting out what you want. They don't become orders. You don't get a hearing date. You don't get any of that. But this is your petition. This is your wish list. You get it filed, and then you get someone over the age of 18 to serve it on the party. And when that person gets that petition is really when this case starts, because then you can either count out 30 days, and if there is no response from the other side, you do have the ability to ask the court to kick them out of the case and continue on by yourself. For default cases, I do like to tell people, even if they think there's a chance of a default, I say be very careful with what you put down in your petition, because you can't change it. The default judgment needs to mirror the petition exactly. Unless that other person, the respondent, is willing to come in and sign under notary, they're okay with 1 or 2 changes. But most of the time, it really is, it has to match it exactly. If it doesn't, if you lay out your wish list and you're like, actually, I put that for custody and visitation, but what I really want is X, it's too late. You're going to have to go back to square one and amend, or get the other side to sign off to those changes under notary. And so that's why wish lists, while they are just wish lists, are important in case it goes default. And then, but then of course, if the other side does respond, it can go one of 2 ways. Either you guys reach a stipulated judgment or an agreement, or you guys end up going down the long path of trial. Now with trial, I do like to tell people, even if you're heading down that path, that doesn't mean that there can't be an agreement somewhere down the line. Trial is a very long path. There's like multiple hearings to get there. You've got to complete your homework, your trial documents, all of that before the parties even get to trial. It could take up to a year, especially post-pandemic world, where it takes you like 3 months for a simple hearing. So if we're talking about that world, it can take a very long time, and people most often end up reaching some sort of agreement before they actually end up going to trial. Now, in terms of the court in Los Angeles or San Diego, or whatever the case might be, having jurisdiction, I am talking specifically about LA, of course, throughout this presentation. But for a divorce, you have to be a resident of California for 6 months and a resident of the county, which for us would be LA, for 3 months preceding the filing date. Same for custody, for child custody. In order for the Los Angeles court to make custody and visitation orders, the child has to have lived there for 6 months. Now, there are some exceptions to this, like emergency jurisdiction and things like that. But those are things that specifically have to be pled. And it's not the norm, let's just say. And there are different ways that parental rights can be established, and they can be established in all of the cases that we talked about. They can be established through a divorce, through a legal separation, through a parentage case, and through child support services action. They can also even be established through dependency courts. I have seen them through there as well. All right, and then so talking specifically about a dissolution. So California is a no-fault state. Legal separation, while it suspends the marriage, divorce is what ends it. So like I said, some people choose to get legally separated for religious or insurance purposes. So they the marriage never ends technically, but divorce is what will actually end it. Same thing applies for a domestic partnership. Now, the fastest that you can ever be divorced, and people get really sad about this, but the fastest you can be divorced in the state of California is 6 months and 1 day from the time that the other side is served. So for a lot of people, I like to tell them, look, even if it's a default judgment, right? Technically, a default judgment can be done within 2.5 months if you're really on it. If you serve them, wait out the 30 days, and then you file your request to enter default and your default judgment, technically the process itself can be finished in 2 months, but that divorce date that's going to come on your judgment isn't going to be for another 4 months in the future. And so, because that's just the fastest that anyone can be divorced here. And in a dissolution court, the court has the power to annul or dissolve the marriage, characterize, divide, and assign assets and debts, and then of course make orders over spousal support, child support, custody, and visitation. Now for spousal support, just a brief little explanation of spousal support. There is a difference between temporary support and spousal support. Temporary support is typically when the parties are separating. You do ask for, you're essentially going from, let's say, a household of 2 incomes to a household of 1. Or for some people, it's the other side was supporting me. I was a stay-at-home father or a stay-at-home mother taking care of the children, and now I have no income. And so the goal of temporary support is basically to maintain that marital standard of living pending some sort of trial. Now, of course, the lower the marital standard of living, the harder it is to achieve. If both of you guys were working, or if both parties were working, making about the same amount, when they're splitting, it's going to be pretty tough to get a support order because it looks like you guys were making about the same, or the parties. For permanent support, there are a lot of factors that actually have to be considered before the court can decide to allow for permanent support. And it can be age, health, the domestic violence, if any, during the marriage, the ability to pay, duration of the marriage, and the factors, what you contributed during the marriage. So you have to go through a whole slew, or people have to go through a whole slew of factors before the court can decide whether, yes, you should have it permanently or not. And obviously, at the end of the day, while permanent support can be until the party remarries or dies, technically the goal is for both spouses to support themselves. And while not written into law, my experience has been that, like, basically paying about half the length of the marriage or more in spousal support, and then asking to reduce it or get it taken off the table. If you can prove that the other side had ample opportunity to have the skills to support themselves, then it could be that support ends. Another weird thing about support is the idea that, with temporary support, obviously it is to maintain that standard of living. Sometimes divorces can be really, really long, and people never request support, or they've been separated for 5 years and they want spousal support. And that's fine. Everybody has the right to ask for it. But the longer that you've been separated, which really depends on the date of separation and not the date that you file, the longer time you have been separated, the less likely the court is to give you support. Because if the point of support is to maintain that standard of marital living, and you've been separated for 5-7 years, then you clearly showed the court that you were able to support yourself. And so it does make it a little bit tougher to get support. Now, yes, spouses do have a duty to support each other, and this is essentially just a repetition of that previous slide. And then when we get to parentage, so the establishment of parental rights entitles children to child support, Social Security, survivors benefits, military benefits, health insurance, inheritance rights. And so these are all really important things. And so that is why establishing parentage and the children having two parents is really important. And again, we went through this, but parentage can be established through marriage, genetic testing, a voluntary declaration, which is typically signed at the time that the child is born. It's used to be known as a POP, or a declaration. I don't even know what the POP stands for, but I think it's essentially a declaration of paternity. But that's usually signed at the time of birth. And it establishes parental rights. So you never have to go through, if you never have issues with custody and visitation, let's say, you have technically been established a parent of that child by signing that. And obviously through court order. Now, nowadays, the court does allow for more than two parents in certain circumstances. I actually have had at least 2 or 3 cases where I was able to establish 3 parents. As time passes, for some reason, it's getting more, it's becoming more and more the norm. But yes, in certain situations, children are found to have 3 parents. And so obviously within divorces and parentage cases, one of the big hot topics is custody. And so we've got 2 types of custody. There's legal custody and physical custody. Legal custody is for the person or persons who are going to make important decisions about the child's life, including schooling, healthcare, religion, and extracurricular activities. Now, I think it's important with legal custody to point out that these are for the important decisions. Let's say you had 2 parents who, while they were together, mom was the one making the doctor's appointments, the checkups, the optometry appointments, the dentist appointments, and going forward, now they share joint legal custody. Well, great. There's nothing stopping mom from continuing to make those day-to-day sort of appointments that she was making beforehand. But let's say in making her dentist appointment, she now has to decide whether the child should get braces. That is an important decision, right? That is a decision that now isn't just the regular day-to-day checkup. Now the parents have to come together and decide whether this is the right time for the child to get braces. That is not for one parent to make the decision by themselves if the parties are sharing joint legal custody. So that's the legal custody part of this. And then we get to physical custody. And this is really who the child is living with primarily. Now, visitation is for the person who is spending time with the child, but it's usually limited time. And so there's, alternate weekends, things like that would really be more of the visitation. And then the person who has them the Monday through Friday and the every other weekend would be the person with primary physical custody. There's also obviously the possibility of joint physical custody. And I will say that in the state of California, the goal is always for both parents to share both joint legal custody and joint physical custody. And so this is really the standard. And if you don't believe that's in the child's best interest, then the burden is on you to show why in your particular case or in that person's particular case, physical custody cannot be shared. Sometimes it can be things like distance. One parent lives in San Bernardino, the other one in San Diego. It's obviously too far for the child to be driving every day to school if the child is attending school in San Diego. Other factors are obviously domestic violence and work schedules. If one parent is working over 40 hours a week and doesn't have the time available to the child, then and the other parent does, then that might say, okay, great, the other parent should have primary physical custody. But again, like I said, technically the goal is for parents to share significant periods of custodial time if they can, and it's the appropriate thing to do. Now, for the court to have power to make orders over children, they obviously have to, so the court must have power to make orders about the children under the UCCJEA. So the court needs to balance the idea of best interest with frequent and continuing contact. Now, there's no such thing as an automatic 50-50. And usually I would say when you're arguing in court or trying to make a point of saying, we shouldn't have equal time, or we should have 50-50, or we shouldn't have 50-50, just that description and the word 50-50 to me rings a bell for child support. It triggers child support for me, because really that is the only time in family law where percentages come into account. When you're talking about spending time with children, I like to describe it as joint physical or shared custodial time or equal parenting time, things like that. But either way, once you guys are fighting custody, or once parties are fighting custody, and I apologize for saying you guys, I am used to talking to way too many clients. When parties are fighting custody, parents are forced to go to mediation. And there are multiple times where parties have to go to mediation more than once. If you're filing a request for order, then the court is going to force you guys to go to mediation before the judge makes a decision in your case. And that really is the court's last ditch effort to get the parties together, get them talking with the help of a neutral party, to see if any agreements can be made. If they can't, it's not a big deal. That's the point of a hearing. That's when the judge will make the decision. But the way that I've heard judges describe it is the idea of, let's see if you guys can figure it out before you have a total stranger make decisions over your child. And I think that's sort of the way they try to describe it to parties, because who knows the children better than their own parents. But it's perfectly acceptable and okay if you guys can't, or the parties can't get on the right page, and they do need a court to make orders. Now, the court can grant custody and visitation to a third party. Non-parents, including those who have been caring for the child, could be grandparents, but those are tough cases to go through. And again, sole custody doesn't necessarily mean that the other side has no rights. You will always have, visitation rights, always have the right to, even if one party has, let's say we're talking about legal custody, just decisions. So while the other side has the ability to make all the decisions, that doesn't necessarily mean that the other side, who doesn't have the legal custody, doesn't have the right to know about those decisions. So they may not be able to participate, but they should be able to at least know and be informed of what's going on in the child's life. And then we have the joint custody. Again, it doesn't necessarily mean, just when we're talking about joint custody, shared equal time, all of that good stuff, it doesn't mean a 50-50 split. All courts are different, but the way I've seen it described is more the idea of anything over like the percentage, if we're talking about percentages, anything over like 70-30%, really the court starts to look at it as a joint physical custody schedule. So it doesn't have to be a straight 50-50 week on, week off. It could be every other weekend with like a weekday overnight somewhere in there, and it starts to add up your time, getting over 30%. And some courts see that as a joint physical custody. And so, yes, the lack of immigration status does not disqualify a parent from having custody. Also, I believe, and this is fairly recent in terms of the court and what they allow in, you're actually not allowed to bring in another person's status. The court is seen as sort of as a safe space. And so to bring up that, they might run away with the child because they're not a citizen of this country is really something that should not be happening nowadays. And the court, obviously, when making determinations for custody, needs to consider issues like domestic violence, child abuse, substance abuse. These are some of the things that also impact this idea that, yes, while it's best for a child to share, while it's best for parents to share equal time with their child, issues like this are going to stop that from happening. And then the court obviously also has jurisdiction over child support. The court is the one to decide on the amount of child support one parent will pay based on both parents' net income and the time share of the higher earner with the child. So, the easy example is to say mom and dad have one child. Dad is making $50,000 a year. Mom is making $25,000. Okay, great. Let's put those numbers into there. The disto master actually, which is what LA uses to compute child support, you actually need to put in, or as attorneys or the parties, you start with a gross number and the disto master itself will actually calculate the net income. And then obviously that, in line with the timeshare that the higher earner has, will spew out a number of child support. Now, there are certain deductions, like if one of the parents has additional children that they are actually supporting. It's not necessarily that you have additional children, it's additional children that you are paying support for or that you are supporting. And then obviously extraordinary health expenses, like if you're paying extra medical care or health insurance, those are the sorts of things that are deductions that can be taken into account. All of the additional things like bills and debt and rent and what you're spending a month on groceries, none of that will be taken into account because generally we all have those expenses. And so the court really looks at those three things. And a court can make, in order for additional child support, for things like childcare necessary for the custodial parent to go to work or to school, for reasonable uninsured medical costs and education costs, and reasonable expenses related to visitation. For reasonable expenses related to visitation, I've seen it where one parent has to pay some of the gas money that the other person has to incur if one party lives far and the other, if the two parties live far away from each other. For reasonable uninsured medical costs, I've seen it too, where parents are having to split the cost of, let's say, braces that aren't typically covered by medical insurance. And so the only thing with, medical costs, additional medical costs that aren't covered by insurance is the idea of you don't want to wait a year before asking the other side, oh, you have to pay 50% of this, right? Or you have to pay half of it. It really is something that they have to be in line with, and that you have to be presenting. I think it's within like 30 days of accruing that cost. It is being upfront with the other side and saying, this is what is, these are the additional costs. And, you know, to wait a year later or 2 years later, it's going to be tough to recover that. The court.
Natalie, I think
Yes.
Nick has his hand up.
Oh, I'm sorry. For some reason, I can't
No
see
worries.
that. Yeah, go ahead. Sorry.
No worries. I just wanted to ask if you could tell the group a few things about like the rebuttable presumption in DV cases.
Sure, absolutely. And we'll get there. Don't worry. There's an
Okay.
entire slide on restraining orders and then sort of how that affects custody and visitation. I don't think it's too far from here. I can quickly go through child support.
No worries.
I promise we'll get there. And so for child support, again, court can adjust guideline support based on the seasonal or fluctuating income of either parent. We generally don't consider the income of the new spouse absent some extreme hardship. The court can order money to be withheld directly from a paycheck, and that's typically through an income withholding order, and it can be for up to 50% of that net paycheck. They can also attach it to property. Employers who fail to comply with this income withholding order are individually liable. And of course, the court can suspend a support obligation during the time that a parent is incarcerated or involuntarily institutionalized for more than 90 days. All right, and then now we get to domestic violence. And so there's a difference between, I guess I'll start at the beginning in terms of an emergency protective order. And so this really isn't having anything to do with a restraining order, but let's say there's an incident, police are called on the scene, and they issue you an emergency protective order. And so this is an order that is issued by the judge at the request of a police officer who asserts that a person is in immediate danger and needs a protective order for up to 5 days. And what this really does, it allows a person to get the protection necessary to then get to the court and file a temporary restraining order. And that's typically the point of an emergency protective order. Now, the domestic violence, a restraining order is issued by a judge at the request of a person seeking protection for themselves, minor children, vulnerable family members from assault, threats, and damage to property. And yes, you can include your pets in a domestic violence restraining order. And so first thing that is ordered is a temporary restraining order, and temporary orders last up to 21 days pending the court hearing. And so the temporary restraining order is really based off the paperwork. Whatever story you have to tell, the party has to tell, there's a declaration involved. And reading that, the court will decide then whether a temporary restraining order needs to be issued, and it will be good for up to 21 days. They try to assign the restraining order hearings within those 21 days so that nobody is losing too many rights in case one person is ordered to have no visitation. And then you go through the restraining order, and if the court decides to grant a restraining order, then the party is issued a restraining order after hearing. These are orders, whatever orders that the court made at the hearing are recorded into this restraining order after hearing, and it can be good for up to 5 years and can be renewed for up to 5 years or even permanently in some cases. A restraining order under the family court does require some sort of familial relationship, whether that's ex-boyfriend, ex-wife. Other than that, I believe it's anything outside of the first degree of a familial relationship. Then if it's anything further out, it really is considered more of a civil harassment restraining order. And the Domestic Violence Prevention Act can be issued as part of an existing case or a standalone case. So let's say it's just a couple who shares a child. There's no custody orders. This is the first time they're going into court, and dad is seeking a restraining order against mom. Great. There's a restraining order. You don't need any other case in order to file. Or if mom has started a divorce and then somewhere down the line feels that she needs a restraining order, she can do it under the divorce. If you have the type of case where you started with a restraining order, but then realize, hey, we need to figure out these, the rest of our divorce or the rest of our parentage case, then essentially that parentage case or the divorce case will become the lead case, and your restraining order will be moved under that larger case. And so, of course, the court can make orders for custody, visitation, child support, and spousal support. And I guess before I go into this next slide, I'll talk a little bit about 3044 and the presumption and the effect that a restraining order can have on custody and visitation. And so if a restraining order is found that it is needed and is granted by the court typically, it's the understanding that it is not in the child's best interest that the victim and the abuser share legal custody or share any type of custody. And so in that case, typically only one party is awarded sole legal custody, sole physical custody of the child, and the other parent is awarded visitation. Now, once a restraining order is in place, for the parent who has the restraining order against them, there is automatically a presumption that is put on them, that is essentially a presumption that they hold for about 5 years, that they should not have custody of their child. Now, there is a way to rebut that presumption before the 5 years. And so let's say 2 years have gone by and the parties are now in trial, and dad, who has a restraining order against him for 5 years, wants to decide that he wants joint legal custody. Well, in order to do so, he first has to rebut what we know as 3044. And so in order to rebut the presumption, there's about 7 things that he has to show the court in order for the court to decide whether he rebutted that and can now have joint legal or joint physical custody. Some of those things include not violating, attending the batterers intervention program, the 52-week batterers intervention program, taking parenting classes, attending anger management classes, attending alcohol and drug abuse classes if the court found that was necessary, not violating the restraining order, not violating any probation if there's a separate criminal case, and essentially showing that it is in the child's best interest that that party have joint legal or physical custody. And so with some of these factors, like the 52-week batterers intervention, the parenting classes, the anger management classes, sometimes those aren't always applicable to all parents. It really is depending on what the court ordered of that parent in the restraining order. If they never awarded a 52-week batterers intervention program, well, then as that person, the one with the restraining order against them, as they are going through those 3044 presumptions, factors, they do have to say, the court didn't order it, like it's not applicable to me, right? What is helpful in a lot of cases is for even when the court does not order a parent to do certain classes, I think that the one that tends to be beneficial that is never really looked down upon is parenting classes, right? Everyone has something to learn from parenting classes. And so I've seen a lot of parents, whether or not they're ordered by the court, take some of these, and that way when they are rebutting 3044, they can say, while the court never ordered parenting classes, I went ahead and took this class for 12 weeks or whatever the case might be. But it's not just saying it. Obviously, it is including all of the certificates of completion to show the court that they have been completed. And again, not violating the restraining order or any probation or anything like that. And then at that point, once that person has presented all of that evidence, it really is for the court to decide whether that presumption has been rebutted enough to now share legal custody or physical custody or whatever it is that person is asking for. And then we get to guardianship. I'm sorry, So guardianship suspends the rights, a parent's rights to care, custody, control, and charge of their child. And it vests those powers and duties with some other adult. Now, it does not permanently terminate their parental rights, but it definitely can lead to that. And I think that that's something really important to understand about guardianship, especially a few years ago. There was sort of this craze in immigration where we weren't sure what was going to happen, and people were trying to decide they wanted their children to be safe. They wanted, in case they were deported, I need someone to have custody over my children in case I have to, be deported. And so they were giving guardianship to their parents or friends or things like that. And yes, while they weren't terminating their rights, what people don't understand is that after 2 years of somebody having guardianship, the guardian can seek to terminate that parent's rights and adopt the child after 2 years. So that's a pretty serious consequence. Also, it is pretty tough to get rid of a guardianship once put in place, because it's not about that parent saying, oh, well, I'm all better now, right? If we're in a situation where a parent, I guess I'll make it easy, maternal grandmother has guardianship over her grandchild because mom and dad didn't have, it was necessary and convenient at the time. And you do have to show that it is necessary and convenient in order for a guardianship to be granted. But let's say they're able to show that. And now mom, 3 years later is seeking to terminate the guardianship. And she's saying, I'm all better now. I'm clean, I'm this and that. And that's excellent. And that's great for her, but that's not the standard that the court is using. The court is not measuring this up against what mom has proven, how good she's come along, how far she's come. The court is only going to terminate a guardianship if it's in the child's best interest. And so if child has been living in a stable household for the last 2 years and is doing well in school, that the person seeking to terminate guardianship is not having to show the court how great they're doing. They have to show the court how it's in the child's best interest that they be returned to them. Okay, which is a pretty tough thing to prove from what I've seen. And then we get to dependency. And a dependency court case can be filed if a child has suffered or there's substantial risk that a child will suffer serious and physical harm. Once a dependency court case is opened, the family court no longer has jurisdiction. So jurisdiction is suspended over issues relating to the child pending a dependency court case. And so you can't go back and if the dependency court has opened a case in your dissolution or in your divorce, the court cannot make orders over custody and visitation while that case is pending. Now, once that dependency case is closed and you have exit orders or a juvenile final judgment, and let's say you have juvenile final orders and you realize 3 years down the line that you have to modify those. You can modify in family court because dependency court jurisdiction has now ended with that final judgment. But while it's pending, they can't do anything about custody, visitation, anything like that. Once it has ended, then they do have the jurisdiction to modify anything. And so that was sort of, before I sort of get into our programs, that was a very quick run through of family law basics. And I guess I'll say, any questions on family law and the basics of that before I sort of jump into Levitt, Quinn, what we do, how we work? Perfect. All right, so I'll go into Levitt, Quinn. So we've got a few programs. We've got about 5 programs, the first one being Kids Fund. And Kids Fund provides very low income parents. And what I mean by very low income, I believe it has to be under the 120% federal poverty line. So we provide them with free or reduced cost representation or services in family law cases that impact the safety and well-being of minor children, including custody, child support, domestic violence. And that's our Kids Fund program. And our Shriver program provides free legal services to low-income families with high risks, high stakes, high conflict custody cases in which one side is represented by an attorney. And this is a program that was started by the court in order to meet that unfair power dynamic that was happening, where one court had this high powered attorney and the other side didn't, and it was a high conflict custody case. And so the court sort of came up with the Shriver Project, and the cases that come from that are typically court referred. Sometimes the way our office works is if somebody's calling in for regular services and it sort of sounds like a Shriver case, we listen to, we do probably like a second screening, get a few more details, and then we will send them to Shriver. The Shriver Project doesn't always like when we do that. During the pandemic, they've been A-okay with it. So it's something we continue to do. So for us, if it's coming through our office and it's just a regular client, that sounds like a regular case, but for us, it triggers, wow, this sounds really high conflict and it looks like he's got an attorney. Maybe this could be a Shriver case, and that way they're able to get free legal services. And then we have our Modest Means program, and this is for people who earn too much for traditional legal services and too little to hire a private attorney. And so to actually get the help that they need. So our sliding scale structure, which is based on the person's gross income and their family size, makes at least access to legal services affordable for these families that are somewhere in between. And then we have our adoption program, which helps families seeking to protect a child whose biological parents unwilling to or unable to care for them through private adoptions. And I do believe that this is one of the very few projects, we're one of the very few nonprofits who will actually deal with private adoptions, either on a sliding scale. And in the adoption project, you are allowed to fall under Kids Fund, Beulah, Shriver Project, and sliding scale. So the adoption project, while one thing, you can be Kids Fund and adoption. And then our last program is our Beulah Fund, and this is a fairly new program, I think about 2 years back, and we provide no cost representation and legal services to senior citizens and adults with disabilities living at or below the 150% poverty line. And the reason we sort of came up with this project is because we were having quite a few clients from the regional center referred over to us. And, it is tough because they're usually living off Social Security, SSDI, whatever the case might be. And so we try to provide them with no cost family law services. Oops. And then we get to Levitt Quinn and our referral process. And I believe I talked to a few of you guys about this, but let's say you guys have a client and you're working with a client and you say, this sounds like somebody who could go over to Levitt Quinn. And so those are what I consider sort of internal referrals coming from you guys, directly from you guys, almost like a sort of soft referral for me. And what we would do is I provided a conflict sheet to, I'm not sure if I provided it to Elaine. I'm not sure who I provided it to, but I gave it to somebody. I attached it to an email, but I can go ahead and attach it to another email if need be. I attached a conflict sheet. It's very simple, one pager. I have it in both Spanish and English. You'd have the client fill that out, email it to me. I will conflict them. And once they pass the conflict check, I can say, okay, great. I will call them. I will ask them what their case is about, what's going on, how we work in terms of limited scope services, what they need for their first step. Everybody's first step in our office is an initial intake. So I guess the way it works is you fill out the application, you get conflict checked, then you get a screening call once you pass the conflict check. If you don't pass the conflict check, we will let you know that we're not able to provide services because there was a conflict in the case. So it's not like we'll just, disappear. But if you pass that conflict check, you will receive a screening call. And the point of that screening call is to see whether we really can assist. There are some cases who, for whatever reason it might be, we just don't have the ability to help or the resources to be able to assist. Some people need discovery and form interrogatories, and our office doesn't do that. So before charging them $45 for an initial intake, we like to hear a little bit about what their case is about, just so that we're not charging them just to say, oh, and we can't help you, by the way. So we like to, before charging anybody, we like to call them, find out what their case is about, If it sounds like something we can assist with, then we go ahead and we explain what our office works like. We explain to them that we are a limited scope office, which means we work step by step. We don't take on anybody's case in its entirety in terms of from beginning to end, and we're handling everything. With some clients, it does end up working out that way, where I've had clients that have been with me, while even if it is step by step, they've been with me 2 years. And I've gone from beginning a petition to now being in trial with a client. But it really is just, a lot of this is based off availability, the attorney availability, the complexity of the case. And I would say that Levitt Quinn, we are known to take on some pretty complex cases. And of course, the resources at the time. And so we sort of explain all of this to them so that they have a general understanding of what they're getting themselves into, right? We don't want anybody thinking they're paying for a private attorney. And so we explain this to them, how our services work. And essentially, now that it sounds like, okay, great, it sounds like something we can assist with, we send them an email afterwards with lining up what our office needs from them. And all of that stuff is on the next slide, so don't worry. This is stuff that you can begin to tell clients that they're going to need eventually if they want to start collecting it. And so we ask for a list of about 5 things. Once we have those things, we go ahead and call them and schedule them for an intake consultation. After the intake consultation, we'll say, great, that next recommended step for you sounds like paperwork or representation or whatever the case might be. And with that proof of income, which they are required to, as part of one of the requirements before the intake, we can say, and it would be X amount, so that there's no surprises later on down the line. And so that's really coming from you guys. And and this will be the same for all clients. The only difference between an internal referral and an external referral is that the conflict checks will be coming directly to me, and I will do my best to get them pre-screened as soon as possible. For regular people who you say somebody called in, they were sort of curious about family law and I want to send them over to you, then it would be, they visit our website, they hit the our services tab, they fill out the application, email it, fax it in. They can go to the office and fill out a hard copy. Obviously, if they don't have a computer, they get conflict checked, and then they will be receiving a call from any Levitt Quinn attorney. So it won't necessarily be me. It could be me, but it could be any of us. And then the things that all potential clients should be prepared to email, fax, or drop off would be an identification, a proof of income, an entire case file. If they're looking to get a divorce, a marriage certificate, if there's any custody and visitation issues, or they're starting a parentage case or a divorce, birth certificates. And of course, if they don't have some of these things, it's not to say, oh my God, I'm never going to be able to apply because I can't get my marriage certificate. Just let us know, right? As we're calling you, we will tell them, hey, I need a list of these things. And if they say, okay, great, I don't have my marriage certificate for this reason, that's fine. Send what you have. We'll work on it later. So just because they don't have all of these things doesn't mean that they can't have an intake. We just would like to hear why they don't have it, right? If the marriage certificate is in a different country, or the other side isn't releasing it, or whatever the case might be, that's fine. You can still have an intake. We can still move past it. Doesn't mean that, they shouldn't apply for those reasons. I think, and yeah,
That's really helpful.
and
I have a couple of questions. In terms of the intake form, if somebody has access to a computer and they can fill out the form, but they don't have access to a printer where they can sign and return the form to you, are you doing DocuSign, or do you have a process for getting those forms back from people?
So getting the forms back, there's no signatures on the applications and on the conflict.
Okay.
There's no signature, so we don't have to worry about that. But let's say they can't email it or fax it back. I'm pretty lenient about people, like, let's say they can't scan, but they can take a picture of something and email it. I'm pretty okay with that. If they don't have access to phones or anything like that, they can mail it to our office. Snail mail, I mean, it will take a while. Or they can, let's say they have the sheet and they don't know how to email it or fax it or send a picture or anything, they can drop it off at the office as well. That's fine. There's always somebody there.
Okay. And Sorry, Nick, one more
Go ahead.
question, or a couple more questions, but I'll ask one and then I'll have you go. Is there any requirement that the client be physically located in LA? Or if they, like, let's say they are responding to an action, other parties represented, would you represent them even if they don't live in Los Angeles?
Yes, the case has to be a Los Angeles case, but that party does not
Okay.
have to live in Los Angeles. I've represented somebody, I believe, who lived in like Alabama or something like that. And it's even better now during remote times. The courts have accommodated to it now, right? The idea that they don't even have to travel down here for a hearing and they can appear remotely has really helped in cases like that. So yeah, no requirement. You can live wherever.
What kind of forms are you using? Do you have like a form automation system or a case management system that they're linked to?
We use Essential Forms.
Essential Forms, okay. In cases where we might have a referral and we've done an intake, part of what we generally seek to avoid is, having survivors retelling their stories and the extent to which we can document things and then kind of transmit them. Is that something that you think might be possible using some of the form software that you have? What I'd like to do, I guess, is what I'm saying is like take a look at those forms and see what I can do to link it to our intake form. Like as we do an intake, or are you looking more for like straight referrals at the beginning?
No, I would say that's definitely something we can look into working together on. Absolutely, especially because most of these things will be coming directly to me. I'll have to
Okay.
talk to Anna about it, and that's something we can loop Anna in on. But I definitely would be interested in that.
Okay.
A couple more questions. I know we've got to wrap up. We're right at time, but quick questions. One is in terms of LA family courts and how they're operating, how much is in-person versus virtual right now?
Right now, I actually haven't been inside a courthouse in a very long time. They're not close to people. It's just the court is really encouraging in person. I don't know what that's going to look like after June 15th. I don't know what the court plans to do in terms of saying, I think it's their plan that remote is working so well for a lot of people that we should continue to do it, especially for those smaller issues. I have always been open, even during the pandemic, to going to court if necessary, whether that person feels that they just need the support. A lot of what I have found is a lot of domestic violence survivors either don't want to go to court by themselves, obviously, and run, being near the abuser. And so I do like to show up for those hearings. Or I have found that remote works really well for them because they don't have that fear of going into court and, the idea of running into them after court, outside the courthouse, whatever the case might be. And so I have found that in a few of my cases, remote has worked really well for those clients.
Definitely. And then my last question is, if somebody calls you and doesn't fit into one of the programs that you mentioned, I guess what are the other options for people? And I'm just trying to get a sense in LA of what the.
Can you give me an example of someone that doesn't sound like they would fit into it?
Yeah. So a divorce that's not like one person, it's not high conflict or to the point where it would fit in. I guess if you pull up the programs, I could I'm thinking divorce because the first one had to be children involved.
Yeah.
Or they're low income but not enough to even afford a lawyer, but not like super low income, so they're kind of in that like in between area.
Yeah. Okay. I totally get that question now. For me, that would be our Modest Means program. Why did this? The Modest Means program. So our sliding scale program, I refer to it as our sliding scale program, but same thing, Modest Means sliding scale. I have plenty of clients in that program that have no issues with custody and visitation. Or sometimes it's like those divorces that that are going to be defaulted. We separated like 10 years ago. I'm just trying to get a divorce. We don't have any kids together. We don't have any property. It's just a simple disso when I want to get divorced. That's our sliding scale program.
But let's say they don't they may not fit into number one because it's a divorce, not a custody issue, but they don't have enough income to pay even a sliding scale.
So I think we like to, it depends. So it's tough for those people. I guess our sliding scale program, the way I think about it, everybody is a case by case, right? If there's somebody that generally needs help and it's like, I truly need this divorce, but I can't afford it. That's running it through Anna and seeing if whatever it is that we can do. Our sliding scale program, if we're talking about, I guess I can sort of tell you guys the way the numbers look or the amounts look. At our lowest amount, our sliding scale is about $60 an hour. So let's pretend somebody needs a divorce. So a divorce petition for us in our office is a block of about 3 hours. So it is about $180, right? And so that's what the pay rate kind of looks like. Now we can always say, look, it's 180. This person says, I really, really can't pay. I can run it past Anna and she can say, well, we can do it at half the cost, or we can do it for free, or whatever the case might be, if they're not exactly falling under Kids Fund or Beulah.
Okay. And Dion has a question. Do we need to specify what program when we're making a referral?
No, we fit them into the program.
Perfect. And then one thing I'm thinking about is that, we have people contacting us with referrals, and there's a number that we're just sending directly to you saying, we can't provide family law services in LA, contact Levitt Quinn. I'm wondering, I would love there to be a secret handshake that we have for those referrals that we want. It's they may not necessarily, calling for family law services, they may not disclose that they're a survivor of human trafficking. And it's something that there's a lot of stigma that comes with that, but it also, it could come up in their cases. It may not. It certainly is something that we would want your attorneys to know in terms of working with them, and that they do have trauma, and they, their interactions may be very different because of that trauma. I'm wondering if we can come up with some way of saying, I don't know if it's just that Free to Thrive gave me your contact info or something like that. That's like a secret handshake that doesn't say I'm a human trafficking survivor.
Yeah. So I was going to say, how comfortable do you think they would at least feel with putting down that they were referred by Free to Thrive? Because our application process, one of the questions is, how did you hear about Levitt Quinn? And, putting Free to Thrive for us could be a trigger. Okay, we're working with someone who is a, sex trafficking victim, or, just be careful, essentially. So if they don't mind putting that, essentially a Free to Thrive somewhere on there, even if it's not directly coming from you to me, we can flag that. And I can definitely tell the office at the next meeting to say, okay, this is sort of what we agreed upon. Like, if you see an intake and it has Free to Thrive, just know that this is the population that you're working with.
Perfect. I think that would be great. And then Dion asked another question. What happens if something develops during your representation, referral for divorce, but visitation and child support or paternity becomes an issue? I think, Dion, correct me if I'm wrong, are you trying to say that it may actually fit into Kids Fund down the road, but it didn't initially? Is that what you're saying?
That is exactly what I am saying. I was trying to keep it low. I was trying to do the low profile.
People can definitely be reassessed. People can come in with a job and then they end up losing their job. We all found that a lot in the last year, right? Where a lot of people lost their jobs. And so, of course, if they say, I used to work there, but now I've been laid off, can I be reassessed? Absolutely. And we'll see if they qualify for free services. Or let's say they started off modest means and then the other side got an attorney and this is turning into a high conflict case. And I'm like, hey, we might be able to save you a lot of money. Let's see if Shriver Project will take you on. Absolutely. That's just,
Awesome.
And attorneys are all trained for that in terms of seeing who needs to be reassessed, listening to clients and all of that.
Awesome. And then the last question, and I'll say it verbally, is if they were referred by Free to Thrive and something comes up to where you can no longer assist them, could we put something in place where you would at least notify us so that they don't just fall off and we can try to get them another referral? Could we put something in place with it being a Free to Thrive referral?
Absolutely. And that's specifically why I want, this was dumb of me, but I didn't actually put my email address on here. Feel free to, I will send you you have my email address. Please share it with everybody. That should have been on the last slide. But that is specifically why I want these referrals to come to me, so that I can keep track of them. And so that I can see what those next steps are, what we're recommending as the next step. And if it's something where, hey, we can only really help with advice in this case, or there isn't another step, or, whatever the case might be, I don't want them to fall off, the grid. And so, yes, that's specifically why I want them referred to me, so that I can track them and so that I can tell you guys where we're at.
Excellent.
Perfect.
Thank you so
That
much.
sounds wonderful. And we're coming to train you and your team about, I think we'll focus definitely on what it means to be trauma informed in terms of working with human trafficking survivors, because our client population is very unique, and also the unique family law needs that our clients present. To give you a teaser, it very often involves litigating against a exploiter, abuser, or sex buyer, and sometimes some combination thereof, and sometimes their family members. A lot of domestic violence cases that present as DV, but there's an underlying human trafficking element, and oftentimes their perpetrators will use their past against them in the family law court, or continue to abuse them through the family law court. So the dynamics of litigating against a trafficker are complicated, to say the least. We'll train you all on that. But we really, what we also will save time for is, we really want to have a close working relationship with you on these cases. We've developed a really strong expertise in this very unique and complex client population. And so we want to be both, we want to refer cases to, because we cannot do direct services in LA at this point. We don't have the bandwidth or the staffing. And, your organization's experience with DV, with, an indigent population is really, closely, it's closely connected to our work. And so we feel like this is a really good partnership, but we don't just want to hand cases off to you and leave you hanging. If issues are coming up in cases, we are completely comfortable with either providing support, advice, or co-counseling. We just can't, we've already have like 5 to 6 referrals for you. We just don't have that kind of capacity. And so I just wanted to share with you that that's certainly our intention, is to really develop a close working relationship with you and your attorneys, and support you in developing this expertise, because it really is highly specialized.
Yeah,
area
absolutely.
of family law.
I am excited. I know that's a weird word to use when we're talking about this, but I am very excited to take on these types of clients. I love everyone at Levitt Quinn. Clearly, we all work there for a reason. We love doing what we do. Our attorneys are dedicated to our population, our cohorts, and so I'm very excited for this opportunity, and I definitely want to keep track of all of it.
Good. And so I'm assuming from this that you are our kind of primary point person for referrals and for just kind of things along the way.
Yes.
Next question.
Excellent. Yay. Well, so grateful for this presentation, grateful for this partnership, and we'll be in touch. And if anything comes up in the interim, I know it's going to be a little while until, I think it's July that we're training you. But by all means, please reach out to us. Nick is our primary family law attorney. So if it's specific family law issues in your cases that are unique fact patterns, contact Nick directly, who's CC'd on my emails with you. If it's just client interactions, Dion is our client liaison, and she is just incredibly skilled at our very complicated clients. They can be, really incredible and also really challenging, to say the least, as I'm sure is true for most family law clients. So I would contact Dion, and if you're not sure who to contact, just contact any of us, and we'll figure it out amongst ourselves.
Awesome. Thank you guys so much. And I'm looking forward to working with all of you guys.
It makes me happy that you're excited.
Well,
That was a good word to use. I'm so excited.
yes, me too.
I'm like,
I was
I
very
was
we are excited too.
Wrong word.
And we'll, we will hone our referral process. We're kind of trying a couple of things right now. Some are just give your contact info and send them. Some is we've done an intake and we're going to make a warm handoff using your conflict form. Some are, there's one that we're sending you that's kind of in between where she's not a client of ours, but we have helped her with resources. And so we're going to pass her, per your information along, but we don't have a whole lot of information to provide you about her. So we're just trying different things to see what is the best for our clients in terms of how to make this a successful warm handoff.
Yeah,
And
absolutely.
may I say one? Oh, I'm sorry.
Sorry.
I'm sorry, Nellie.
As we're just sort of working, working this out, obviously you guys are trying to refine your thing. We'll see sort of what works on this end as well. And if I can find a better way of doing this in terms of keeping track and doing all those things, obviously I will let you guys know.
Awesome. The only other thing I was going to say is that while it can be frustrating going back and forth, or even working with the population that we're sending, we just want to keep the lines of communication open, that we continue to develop the relationship to support and serve the clients that we are excited to help. And so I just want to make sure that that stays open, no matter how frustrating I can make you. Sorry.
Not at all.
Well, thank you so much. Have a great long weekend. And I look forward to coming and meeting your team very soon.
All right. Same. Thank you guys. Have a great weekend.
You too. Take care.
You too.